Like any other profession, there are good law enforcement officers and bad law enforcement officers. I believe that most Leos are good men and women doing a difficult and dangerous job, often with little respect because of the actions of bad Leos. For years, courts have been protecting these bad officers through their rules and doctrines. A recent Supreme Court case finds that one of those rules violates the Constitution of the United States. So let's take a look at that next on the Constitution Study.
Neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read instead of the Constitution. Teach your and generation be free. Glad you could join me today. You know, people have love-hate relationships with law enforcement. They want them there when their rights are being violated, but they don't like interacting with them at any other time. Which is why this case is so important, because the responsibility of a law enforcement officer must come with the consequences for their bad behavior. And for too long, that's kind of been swept under the rug. Now, if you'd like to find out more, you can go to the article on the website, constitutionstudy.com, and you can double-check my sources. You can also see if there's other content there you'd be interested in. I'll talk more about the website and other ways you can work here with the Constitution Study at the end of the episode. But for now, let's take a look at this police use of force question. As with any case, the details matter. On the afternoon of April 28, 2016, Roberto Felix Jr., a law enforcement officer patrolling a highway outside of Houston, received a radio alert about an automobile on the road with outstanding toll violations. Felix soon spotted the car, a Toyota Corolla, and turned on his emergency lights to initiate a traffic stop. The driver, Ashton Barnes, pulled over to the highway's shoulder. Parking his own car just behind, Felix walked to the Corolla's driver's side door and asked Barnes for his license and proof of insurance. Barnes replied that he did not have his license with him and that the car was a rental in his girlfriend's name. If this was a rental car, then most likely Mr. Burns was not the one who committed the toll violations. Now, I've been concerned about this before because I've been in locations where you cannot just pay the toll. You have to have a toll tag, which many rental cars do not have. As he spoke, Barnes rummaged around through some papers inside the car, causing Felix to tell him several times to stop digging around. Felix also commented that he smelled marijuana and asked if there was anything in the car he should know about. Now, rummaging around during a traffic stop is one way to make an officer nervous. I'm rather suspicious when an officer suddenly claims to smell marijuana. It seems to be frequently used as an excuse to search a vehicle. And, of course, how does the driver argue that the driver did not smell something? Barnes responded that he might have some identification in the trunk. So Felix told him to open the trunk from his seat. Barnes did so while also turning off the ignition. All that happened, as a dash camera recording of the incident shows, in less than 2 minutes. Again, having your ID in the trunk can certainly heighten an officer's anxiety. While things have not gone smoothly, nothing life-threatening has happened yet. Then things began to move even faster. With his right hand resting on his holster, Felix told Barnes to get out of the car. Now, Barnes opened the door but did not exit. Instead, he turned the ignition back on. I'm not sure what caused the officer to reach for his firearm, but he did. That might explain Barnes' concern that his life may be in danger. I'm not saying fleeing was a wise thing to do, but justified or not, the officer threatened Barnes with a deadly weapon while asking him to get out of the car. Felix unholstered his gun and, as the car began to move forward, jumped onto his doorsill. In response to Barnes' dangerous move of trying to flee, Officer Felix pulls his weapon, then jumps onto the doorsill. I'm not sure if Felix even knew what he was going to accomplish by jumping onto the car. It was probably a simple reflex. He shouted, "Don't effing move," and with no visibility into the car because his head was above the roof, he fired 2 quick shots inside. A blind shot like this is extremely dangerous. First, the use of deadly force requires officers to reasonably believe that they or an innocent bystander is in imminent danger. Second, because Felix could not see where he was shooting, he could have easily shot through the window or hit a bystander. As every conscientious gun owner knows, you are responsible for every round from the time it leaves the barrel of your gun until it stops. Barnes was hit but managed to stop the car. Felix then radioed for backup. By the time it arrived, Barnes was dead. Thankfully, Barnes was able to stop the car before he died. Imagine the car careening down the highway with a dead driver and an officer hanging onto the driver's side door sill. Now, all of this happened very quickly. All told, between 5 seconds elapsed between when the car started moving and when it stopped. And within that period, 2 seconds passed between the moment Felix stepped onto the door sill and the moment he fired his first shot. Obviously, there was no planning or training for a situation like this, but the actions of both Barnes and Felix led to this court case. It should surprise no one that the death of Barnes at the hands of a police officer would lead to a lawsuit. Barnes' mother sued Felix on Barnes' behalf, alleging that Felix violated Barnes' Fourth Amendment right against excessive force. Except the Fourth Amendment doesn't say anything about excessive force, unless she claimed that the force used made the seizure unreasonable. The district court granted summary judgment to Felix, applying the Fifth Circuit moment of threat rule. The Court of Appeals affirmed, explaining that the moment of threat rule requires asking only whether an officer was in danger at the moment of threat that resulted in his use of deadly force. Under the rule, events leading up to the shooting are not relevant. Here, the precise moment of threat was the 2 seconds when Felix was clinging to a moving car. Because Felix could then have reasonably believed his life was in danger, the panel held the shooting was lawful. And once again, we see the courts making up a rule that is both irrational and unreasonable. Take this case, for example. The district court said that the moment of threat was the 2 seconds when Officer Felix was clinging to the car. They completely ignored the fact that the officer put himself in that situation when he jumped on the car. And that's just the beginning. The moment of threat rule applied below prevents that sort of attention to context and thus conflicts with the court's instruction to analyze the totality of the circumstances. By limiting their view to the 2 seconds before the shooting, the lower court could not take into account anything preceding that final moment. So, for example, they could not consider the reasons for the stop or the earlier interactions between the suspect and officer. And because of that limit, they could not address whether the final 2 seconds of the encounter would look different if set in a longer time frame. The traffic stop was for an alleged toll violation, hardly a dangerous threat to others. Yes, during the stop, Barnes did help escalate the officer's tension by not having his identification on him, by rummaging through his stuff, and of course, driving off. But does that lead a reasonable person to conclude that it's also reasonable that Mr. Barnes was a danger to others? A rule like that, which precludes consideration of prior events in assessing a police shooting, is not reconcilable with the fact-dependent and context-sensitive approach this court has prescribed. A court using a use-of-force case cannot review the totality of the circumstances if it has put on chronological blinders. How can a court consider the reasonableness of the use of force without the context in which it was used? After all, you wouldn't consider the shooting of someone while ignoring the fact that they had broken into a home while armed. While the court was unanimous, Justice Kavanaugh wrote a concurrence, which Justices Thomas, Alito, and Barrett joined. I found Kavanaugh brought up a few interesting points worth looking at. I join the court's opinion. I agree that officers' actions during the traffic stop in this case should be assessed based on the totality of the circumstances. I write separately to add a few points about the dangers of traffic stops for police officers, particularly when, as here, the driver pulls away in the midst of a stop. Now, Justice Kavanaugh agrees with the court's opinion, but wants to add a few points, specifically how dangerous traffic stops are. Even for routine violations, traffic stops are fraught with dangers to police. An inordinate risk confronts an officer as he approaches a person seated in an automobile. That's from Pennsylvania v. Mims. That is in part because the officers operate at a tactical disadvantage when approaching an unknown vehicle with limited visibility and unpredictable threats. As the court noted nearly 50 years ago, a significant percentage of murders of police officers occur when the officers are making traffic stops. Traffic stops remain highly dangerous today. Now, law enforcement is a dangerous job, and within that job, I can see how traffic stops are one of the more dangerous activities we ask officers to undertake. The question is, does officer safety supersede the safety of those they engage with? What should the officer do when a driver flees from a traffic stop? There are no easy or risk-free answers. Every feasible option poses some potential danger to the officer, the driver, or the public at large, and often to all three. And an officer in that situation must make a split-second choice among those various dangerous options. Justice Kavanaugh's statement is absolutely correct. It's why law enforcement officers require so much training. In such split-second situations, there's no time to think or analyze. In these situations, officers revert to their training. Hopefully, that training would lead an officer to consider situations and possibilities before and during the encounter. So when the moment of decision comes, the reactions tend toward the best outcome. But what about when something happens that the officer is not prepared for? As happened here, the officer could attempt to stop the fleeing vehicle at the outset by jumping on or reaching into the car. The dangerousness of that option is readily apparent. Perhaps the driver will hit the brakes once he realizes an officer is clinging to the car or attempting to reach through the window. But if the driver does not slow down, then the officer may suffer serious or perhaps fatal injuries. The officer could try to fire his weapon to incapacitate the driver and bring the car safely to a stop. But the car may be just as likely to go careening into traffic, thereby threatening the safety of the officer, other drivers, passenger, and pedestrians, and more. A lot of bad situations and bad options for an officer to choose from, with no time to consider. I'm curious as to what training led Officer Felix jumping on the door sill. Of course, when an officer uses force against a fleeing driver, the judiciary still must address any resulting Fourth Amendment claim under the standard of objective reasonableness. Under this court's precedents, this inquiry involves a careful balancing of the nature and quality of the intrusion on the individual's Fourth Amendment interests against the countervailing government interests at stake. So the court sees balancing interests. On the one hand, the subject has an interest in surviving the encounter. On the other hand, government has an interest in protecting the rights of others. The court talks about a balancing, but how many courts place their thumb on the side of government's interest? How often do courts simply take the word of an officer unless there is physical evidence to contradict him? I go on. The point here is that when a driver abruptly pulls away during a traffic stop, an officer has no particularly good or safe options. None of the options available to the officer avoid danger to the community, and all of them require life or death decisions that must be made in a few seconds in highly stressful and unpredictable circumstances. I agree, there aren't any good options when a driver takes off from a stop. Of the bad options available, I think jumping on the vehicle is probably one of the worst. In this case, it wasn't Mr. Barnes who put Officer Felix in jeopardy, but his own jumping onto the door sill. But this case isn't about the traffic stop or the officer jumping on the door sill, but the reasonableness of the shot. Specifically, how do courts evaluate the reasonableness of a use of force? The district and circuit courts both use the moment of threat rule, meaning that in this case, the court looked only at the 2 seconds between the officer jumping on the door sill and pulling the trigger. Held that a law enforcement officer used excessive force during a stop or arrest is analyzed under the Fourth Amendment, which requires that the force deployed be objectively reasonable from the perspective of a reasonable officer at the scene. The perspective of a reasonable officer at the scene. What about the perspective of a reasonable subject at the scene? Would a person who's been pulled over for a toll violation consider it reasonable for the officer to reach for his sidearm? While the subject was rummaging through his stuff, the officer having his hand on his weapon would be reasonable. But after that, that is why the totality of circumstance is so important to the analysis of reasonableness. The inquiry into the reasonableness of police force requires analyzing the totality of the circumstances. That analysis demands careful attention to the facts and circumstances relating to the incident. In other words, police use of force does not happen in a vacuum. Everything in the encounter leading up to the use of force is important to the analysis. In this case, the court should not have looked solely at the moment before Officer Felix fired the shots, but his actions beforehand and the actions of the driver. Was Officer Felix's life in danger because of what Barnes had done or because of what he himself had done? Was the action of driving away from a traffic stop really worth Barnes's life? The recognition of this need to look at the totality of the circumstances is very important. For example, if a person shoves a police officer, that could be considered assault, justifying the use of force to detain the subject. However, if the officer initiated contact, say by intentionally walking into someone, then it's not an assault on a police officer, but a person defending themselves from assault. The decision of the circuit court was vacated, and the case was remanded back for further review. Whether the court finds the use of force reasonable or not, hopefully they will use the right standard for doing so. Now, some of you may remember I looked at the oral arguments in this case some months ago, and this may sound a little familiar, but this is the decision. This is the opinion of the court. And I'm glad they found the totality of the circumstances as the proper analysis mechanism. I've seen plenty of encounters with law enforcement, videotaped, obviously, where officers escalated a situation into violence. They then claimed victimhood. They would get in a person's face, push against them, shove them back, even lay hands on them, and then claim a assault on police officer when the person pushed back. Now, if you only looked at the pushback, well, hey, that's a use of force. That's a moment of interest. That's wrong. But when you look at the totality, the officer initiated that. This is important. As someone who's carried a firearm for many years, I've studied the law on this, and the whole idea is if you're going to use lethal force, not only do you have to have a reasonable imminent threat of imminent violence, but you cannot be the one that initiated the situation. That's where I think Barnes may have gotten in trouble here. Now, I'm not talking about the traffic stop. The traffic stop was legit. The question is, when Barnes fled, was the best reaction to jump out of the vehicle and put himself into danger or not? I think that's what the court really needs to look at. And it should look at it not simply from the standpoint of guilt or innocence, but severity. In other words, was this manslaughter or murder? What degree? That's what I think should be done. I'm glad for this decision. And for once so far, I actually found a case where the court came to the rational decision actually following the law. I like that. Now, if you have a situation that you think maybe law enforcement went too far, or maybe you know something's going on, there's always open discussion. I see plenty of videos on YouTube about that. And a lot of people discuss a lot of things. Sadly, a lot of people make assumptions that aren't true. That's why I encourage people to read and study the Constitution, teach the rising generation be free. That's why I wrote the book, The Constitution Study, so that people could study the Constitution without all the legal mumbo jumbo and academic malaise they put on top of it, trying to make it hard to understand. It's really fairly simple. You can find that and other books at constitutionstudy.com/shop. Now, if you'd like to support the work that we're doing, not only can you buy a book, but, well, you could simply donate to the cause. Nobody here takes a salary. Nobody here gets money for doing this. We pay for all of this. So if you can help, that'd be greatly appreciated. If you'd like to volunteer to help do some work here at the Constitution Study, that would be appreciated as well. Contact me through the website. Just go to constitutionstudy.com and look under About Us, Contact Paul. You'll find me and you can send me a note. You can also support us through Patriot Mobile, America's only Christian conservative wireless provider. See, they've got great 4G and 5G coverage all across the nation. Their customer support's 100% US based. But best of all, when you pay your bill, a portion of every dollar goes to support organizations that are defending your rights. Turning Point USA, Folds of Honor, and yes, the Constitution Study. If you go to patriotmobile.com/constitution, you can find a plan that works for you. See if you're eligible for a discount. Veterans, first responders, even families with multiple lines are eligible for a discount. And when you check out, don't forget you can use the code Constitution to get your line activated absolutely free. So give it a try. Check it out. Go to patriotmobile.com/constitution to find a plan that works for you. Don't forget that code Constitution at checkout to get free activation. Most of all, I hope you'll share the work that we're doing here. Let other people know about us. Let other people know about the work that we do. And hopefully you'll come back and bring a friend or two the next time we meet for the Constitution Study.